Yes, Counsel. Good morning.
Good morning, Chief Justice and Justices. I'm Ethan Stiles, and I appear on behalf of the defendant, Michael Gomes, who has since 2009 been seeking resentencing in his rape conviction, and he has sought a straightforward application of this court's decision in 1984 in Commonwealth v. Coleman and in the companion cases that state clearly and unequivocally that a sentencing judge cannot take the defendant's veracity or alleged lying in consideration when he's being sentenced, and that's precisely what the trial judge in this case did.
What should we make of the fact that this issue was not raised time and again for, I don't know, 9 years?
Well,
Did he
Judge,
have opportunity to raise it? Direct appeal, motion for new trial?
well, absolutely. He did have a direct appeal, and he did file a motion for new trial pro se, and he did not raise it in those. And of course, by the settled rules, the argument is waived. But Commonwealth v. Simmons, the case the court decided in 2007, speaks to this issue. In that case, there was a very similar sentencing challenge. There was some ambiguity of what rule of Massachusetts rule of criminal procedure, Rule 30, applied. But nonetheless, this court held that that waiver notwithstanding and prior attempts at review that did not raise the issue, that the issue could be decided by this court because it's still raised to a substantial risk of miscarriage of justice. And that's what we claim here, and that the cases that have been this case is indistinguishable from all other cases that have been decided heretofore, and therefore he should be entitled to resentencing, even though he did not raise the matter before for several years.
What's this? It may be in here, but what's his status right now?
He's at MCI Norfolk. He'll be there for some time.
Still some time.
Yeah, so he's still in prison. So he doesn't lose standing by virtue of the fact that he may be on probation or he no longer serving the sentence. He's serving this sentence, and therefore the court does have power to directly affect him. Now, in this case, the trial judge, quote, wanted to say a couple of things that were the basis for why I am imposing the sentence I am, quote. And among those things are, quote, I am affected by the testimony of the defendant who told a story that was really not believable at all, quote. And that remark, the second remark, came within one transcript page of the first remark. And after this not believable remark, she continued to talk about why the story was not believable. And she might as well have said something to the effect of, oh, what a terrible web we weave when we first practice to deceive. And that was the clear import of her statement. And since she went on for a whole paragraph on this matter, it cannot be said that her statement was an offhand remark, an irrelevant tangent, an afterthought, or anything that might suggest that this had no effect on her sentencing decision. Now, I have pointed out in my brief that the comments in other cases which the court has found objectionable are quite clearly indistinguishable from these comments. And this court has consistently applied this rule, as has the appeal court, except in one instance, which I'll get to in a moment. But even in the most recent case from this court in this issue, with Commonwealth v. Henriquez in 2003, the court remanded for resentencing where the trial judge had listened to the prosecutor's sentencing argument, which asked the judge to consider the defendant's veracity in testifying, and the judge considered that adopted the Commonwealth's recommendation without further comment. The court was clearly concerned that the appearance of justice was not served in that case where the trial judge arguably may have taken those remarks into consideration, and here we have a clearer case. Now, the one case that there was not applied was the appeals court decision in Commonwealth v. Coleman, which this court reversed. In that case, the court held that the trial judge may have made some regrettable comments, but he otherwise only used permissible factors in making a sentencing decision. And this court said no. The comments infused the sentencing decision, and therefore resentencing had to be done by a different judge. In this case, the trial judge has been retired. Now, in this case, there is seeming clear because, first, the judge was clear and unequivocal that she considered this that she considered this factor. And unlike Coleman, where eventually after some badgering, the defendant admitted that he lied, here the defendant has stood on his innocence since and up to this point, and still does. So essentially we have this Rule 128 unpublished opinion that's in direct contravention of this court's jurisprudence and the appeals court's own jurisprudence heretofore. And I think I know that the justices had solicited and made an announcement for amicus briefs, and perhaps that may have been some attempt to find some other view, since the views given in the Rule 28 opinion are so short and brief as to suggest that the court really didn't consider the defendant's argument with any great care and summarily and treat with summary contempt almost. Now, no case that I have found on this issue seems to suggest that there's some way to distinguish it. The appeals court said in its Rule 128 decision that, well, in consideration of all the factors, we don't feel that this improper comment had made a substantial risk of a miscarriage of justice. But there is no other case that they cite in that opinion which would support that argument, and I could find no other cases that would suggest, especially from this court, that that was a permissible argument. I mean, that was a permissible approach to take. And this court has said that these remarks, that remarks like this, if shown to have an effect on the trial judge's decision, do rise to a substantial risk.
So what's the relief you want?
Well, we want that this court remand to the Superior Court for a new sentencing hearing. That is the traditional relief that's always been given in these cases. And of course, there's no issue of whether it's the original judge or not, since she's retired. So that is what we are asking the court to do. And I think it is also important that the court do this, because right now there is this Rule 128 decision out there, and while it is not controlling law, nonetheless it has some kind of life and presence, and it's this court's responsibility respectfully to correct error and to correct it in an unequivocal manner. If otherwise, then the clear jurisprudence that's been developed over the past 30 years will be invariably clouded, and there will also be a real chilling effect on the defendant's decision on whether to take his constitutional right to testify. If he thinks, well, if the judge doesn't believe me, I'm going to get a stiffer sentence. So that the court recognized in '84 that it should be avoided, and we would ask the court continue to recognize it today, and not have to force defendants to make that decision, or invite judges to revisit the forbidden factor. Now, if there are no further questions, I will rest on my brief.
Thank you, counsel.
Thank you.
Good morning. May it please the court, Roger Michael for the Commonwealth. I couldn't help but notice it's almost 20 years to the day since I was last in the SJC. Less commodious and luxurious surroundings at that time, but I have to say also that I wish I were here under more typical and frankly less humbling circumstances. I appear today to move to strike the Commonwealth's brief in this case that was filed. I will also be filing a motion today to enlarge the time for the filing of amicus briefs, as I'm led to believe that an amicus brief will be filed in this case. I don't know if any others have been received.
You moved to strike the Commonwealth's brief?
Moved to strike the Commonwealth's brief because I believe that it both misstates the law and also because...
And who are you representing here?
I'm representing the District Attorney of Bristol County.
Oh.
I believe that it both misstates the law and also does not fairly represent the position that the District Attorney takes with respect to this case. This case was brought to my attention about 48 hours ago, and I understand that what I'm suggesting today is extraordinary. I think that the appeals court, in fact, got this case correct. And I also think that as I will explain, that there is a good reason to reconsider the holding in the Coleman case here. Starting
So can I
first
just
with
clarify?
Yep.
You recognize that there's Coleman
Yep.
that would apply. What you're suggesting is we should depart from Coleman.
Well, let me say this. I think that even consistent with Coleman, the appeals court result can be justified. The appeals court, and I'll start there, seems to have taken the view, I think, and as my brother said, the appeals court opinion is quite brief, so it is hard to discern the rationale of the case. But I think they were saying either of two things. Either they were saying that in the circumstances here, that is to say, a case involving a very serious set of charges, the rape of a young woman disabled with cerebral palsy, confined to a wheelchair. The defendant received a sentence of 15 to 20 years, not an atypical sentence considering the charges. It was a sentence also that was right at the median of the recommendations of the defense and the Commonwealth, that in those circumstances, it is not possible to say that we are confronted with what amounts to a miscarriage of justice sufficient to provide the court with a basis for exercising its extraordinary equitable authority to correct a gross injustice.
Michael, have you filed anything to withdraw the brief of the Commonwealth in this case?
We spoke to the clerk on Friday and stated our intention to do so, and we'll be filing a motion today.
And how long have you, in this case, was accepted on further appellate review when?
It was accepted on further appellate review, I believe, in September.
September of 2012. And
September of 2012?
I believe that's correct.
so you've known about, your office has known about the fact that this matter is to be presented. I assume the brief that was presented to us was the same or comparable to the brief that was furnished to the appeals court?
Yes, that's correct, Your Honor.
It's the same brief.
It is essentially the same brief.
All right.
I would say along those lines.
And
that
why should we allow, I mean, you've prejudiced
Yeah.
the defendant here. Why should we allow anyone, especially a DA, to do what you're asking us to do?
Well, Your Honor, I think that when a situation arises where the law is misstated in a brief, where there's good reason to consider alternative approaches to a question, that it's to your benefit, to the Commonwealth's benefit, everyone's benefit, to allow us to at least present the material to you for your consideration.
You've
Well,
been
how
in
would
the...
that work?
How would that work?
Pardon me?
We have to rebrief the whole thing, give Mr. Stiles another chance to respond? Hello?
That would be an option that would be open to the court, yes. The alternative approach, I think, to making sense what the appeals court did here is to I think, challenge the question that's reflected pretty clearly in both the briefs that were filed in the case, that I think suggests that somehow when a judge looks to these kinds of factors in fixing sentence, that it amounts to something akin to structural error. There's really no a sense of a need to discern if there's been, in fact, a prejudice resulting from the consideration of the improper factors. And the appeals court, I think, tried to look to see in the record whether or not indeed there was evidence that the judge, having considered potentially an improper factor, whether or not that indeed affected the judgment that was ultimately rendered. And again, to the extent that the sentence imposed was less than what the Commonwealth had requested, the lower number, the minimum number to be served, is about in the middle of what the two parties had recommended. I think there's strong evidence here, perhaps absent in Coleman, that the court, in fact, was not led to enhance the sentence by consideration of an improper factor. I think it's also fair to point out that the U.S. Supreme Court, virtually every state that has considered this issue, has rejected the approach that Massachusetts has taken. And so in deciding whether or not something amounts to a miscarriage of justice, I think it's fair to look to what's happening in other jurisdictions in making that assessment. I would also say along those lines that in view of the fact that that Coleman was a split decision. It's a decision that's some 30 years old. It's a decision that is out of step with the Supreme Court's approach and the approach of every other jurisdiction that's looked at this, that perhaps this is an appropriate occasion to consider whether or not that rule should continue to be implemented in Massachusetts. There are lots of good reasons that judges should be permitted, A, to rely on this factor, and B, to document their reliance in their sentencing colloquy. The issue of a defendant's veracity on the stand certainly runs to the issue of amenability to rehabilitation, and that's a factor that judges are permitted to look to in fixing sentence. It also provides a better basis for determining whether or not a sentence was fairly imposed when the record reflects a complete description of all the factors that a judge in reality used to fix the sentence. So in this case, I would urge the court to consider adopting the rule that is adopted by all other jurisdictions.
You
including the
filed
Supreme
any
Court.
paper at all, Mr. Michael, in this case yet?
No,
None? Zero?
No, I'm here at the request of my superiors to make this presentation today upon review of the materials that were filed in the case. If there are
Anything else?
no further questions, thank you very much.
Thank you.
Thank you.
All right. Hear ye, hear ye, hear ye.